Like you said, my name is Dr. Kelly Kirkpatrick, and I study American politics, public policy, gender studies, but I did all my research in reproductive politics during my doctorate and still continue to do so today. I more specifically focus on assisted reproductive technologies, but a lot of the abortion questions really relate to this, as we'll get to a little bit later in our discussion today. So excited to have this talk today and answer questions.
Hi, I'm Edward Kammerer. I study the law and LGBT politics and legal activism, and I teach a lot of classes on civil rights and civil liberties, of which, for now, reproductive rights are one. And so that's how I sort of come in here at this approach, is thinking about the constitutional law that supports or may support reproductive rights as a civil right that is enshrined in the Constitution. All right, and with that, we'll get started. Am I clicking?
You can click to your heart's content.
Okay. Did I do it right?
You did.
We're
Excellent.
good. All right, so we're going to start with some history. One of the things to understand with law is it evolves slowly. Law is a very slow, generally moving entity, and the history does matter a little bit. So we're going to give you some historical context to start. So under the common law, and common law, for those of you who don't know, is sort of judge-made law that was the foundation of the American legal system at the founding, when the Constitution was adopted, and through really to the 1850s is when you mid-1800s is when you start to see more statutory law being created. So that's statutory laws passed by a legislative branch. But for a lot of our history, and even through today, judges have made law. They always make law. And so the common law is that judge-made law that sort of guides in the absence of legislation. And under common law, abortion was not regulated. The common law did not really consider abortion to be a crime, to be a thing that they were concerned about. It was like a kind of a you do you situation. The only time it really was prohibited was after what is called quickening. And so quickening is a term that refers to the moment when the woman first feels the fetus move. It was at that moment when the woman became quick with child, which is what the statutes refer to, or the common law would refer to as quick with child. And the theory behind that was that the quickening, the moment the fetus became animated, that's when the fetus became a person with a soul and with movement and life. Prior to that, it wasn't a thing that the law was concerned with because it didn't have those attributes. And so the quickening was the only moment when early law rather regulated abortion. Prior to that, it was kind of, if you do what you need to do. So we don't actually start to see the criminalization of abortion in the United States until the 1800s, 1847. We start to see the criminalization through statutory law. And this was largely done by the American Medical Association, which Dr. Kirkpatrick will talk about in a second. But this was done primarily because the doctors who were part of the American Medical Association wanted a monopoly on all medical or medical-related procedures. And prior to this, abortions were largely performed by midwives, i.e. women. Can't be having none of that. And so this was very much the male doctors coming in and saying, no, this is our realm. We have to do this. And this process started in 1847, and the American Medical Association lobbied for all states to adopt this. And by 1900, abortion was illegal in every state. So this campaign took roughly 50 years. And the only exceptions at this time were those that were approved by the doctors themselves. Usually this would involve something like the life of the mother was at risk. Sometimes it would be for the health of the mother, but the regulations were controlled by the doctors. Those same ones who wanted this process that had previously been legal to be now criminal. And that's...
Yeah, so I don't really have too much more to add to what Dr. Kammerer said about the role of the American Medical Association, except that, like he said, prior to that role, it wasn't really abortion, reproductive health care. Those were issues that were very private issues. It was dealt within the family. People consulted with their clergy. People consulted with midwives, or what was sometimes called wise women, where this was kind of like shared personalized knowledge about a woman's own body. So a woman's own knowledge of her body was considered more of a priority. And then when the American Medical Association came around and became a lot more professionalized, like I said, they wanted to keep a monopoly on who got to hold the knowledge. And so we call this the medicalization of the body, or medicalization of abortion. This is also a little bit what started to politicize it as well. During World War II, we had a lot of technology being developed and a lot of sonar technology being developed. And after World War II, that led into the development in 1950 by some people from Scotland that developed the sonogram. And this was, quote unquote, the window into the womb. So before, like Dr. Cameron was mentioning, we said, prior to quickening that, abortion wasn't something that people really had too much concern about. But now, even very early, you could use the sonogram and you could see something that resembled a tiny human. And that really led to a lot of conversation about, okay, what do we do with abortion? The other thing that I think is really interesting was assisted reproductive rights, or assisted reproductive technologies also started to lead to the politicization.
It's a long day.
Yeah, politicizing abortion. And what happened was there was the development of, quote unquote, the test tube baby, right? And so prior to this development, it started off in the UK. The United States, there wasn't much of that research going on or that happening. And there was no regulation of it whatsoever. And so there was a doctor in New York, and he decided to try to help this couple have a baby by fertilizing an embryo outside of the womb, and he was keeping it alive in an incubator. And the folks in the hospital, the administrators, they got word that this was happening. And they were like, what are you doing? This is Frankenstein type science, shut it down. And he continued to keep his research going. And one night, one of the hospital administrators came into his lab and saw that these embryos were still in this incubator. So the hospital administrator went over and yanked the plug. And obviously the embryos did not survive. And so this couple that had donated their gametes to be able to have this embryo and were hoping for to be able to do some sort of in vitro fertilization, they came in and they ended up suing, and it went clear to the Supreme Court. And the Supreme Court, in the some of the testimonies and also sometimes out in media coverage, the intended mother, she stepped forward and said, when that administrator unplugged the incubator, he killed my baby. And this was the very first time that an embryo had been referred to as a baby. And that really started to politicize everything, from taking it as more of a medical type of conversation into the realm of life.
Okay, so we moved from criminalization of abortion to beginning of decriminalization. And so as it becomes more of a medical procedure, we start to see it regulated more like other medical procedures, right? You have to require certain informed consent, regulations around safety to make sure the procedure itself is safe. But we start to see states no longer consider this to be a criminal matter. And so we see Connecticut enacting criminalization laws in 1821, using that quickening distinction that I mentioned earlier. But then we move into the era of the 1960s, when we see states begin to adopt the model penal code. So the model penal code was a bunch of lawyers got together and said, you know what, we should make the criminal law make sense. Let's make a code. And so they developed this model code that a bunch of states could just adopt. They're like, hey, we wrote, this is what should be criminal, this is what should not be criminal, here you go. And some states adopted this in whole, some states adopted it in part because it was a model. Like you could take what you want from the model. And we start to see, under the model penal code, abortion become legal when there are certain things that can be done. So we get 3 exceptions under the model penal code that sort of preserve some access to abortion. There are exceptions to save the life of the mother, to preserve the health of the mother, which is broader than most states had at that point in time. And some states interpret that to include mental health and other things, or where the fetus was deformed. So if the fetus was going to be deformed, then an abortion would be permissible. But this is sort of liberalizing previous laws that had been actually quite strict. Most states adopted some restrictions, but we start to see those are the common restrictions when states do this. Just a bracket, the Model Penal Code was actually really progressive for its time. The first state to decriminalize homosexuality did it because they adopted the Model Penal Code and didn't realize what they did. So that just gives you an idea of how progressive the Model Penal Code was for its time. It did not consider homosexuality a crime, and sort of we're moving in that progressive direction, so sort of trying to make criminal law better. But not all states care. So several states had upheld abortion access prior to the Supreme Court stepping in with Roe versus Wade, which I'll get to in a second, under state law. So state constitutions can give more rights than the federal constitution, right? The federal constitution kind of sets a floor for your rights, and states can give more if they want to. So prior to the federal constitution recognizing an abortion right in Roe versus Wade, several states, California in 1969, Wisconsin and New Jersey, adopted state constitutional rights to an abortion under their state constitutions, focusing in these states on the right for the woman to choose to continue her pregnancy. So it was separated out from the health, the medical conditions. This was a choice framework that was adopted prior to Roe versus Wade. Roe does mention a woman's right to choose, but it's always in conjunction with the doctor's right to advise. The Roe versus Wade, this is actually a criticism that Ruth Bader Ginsburg had of the decision, like the reasoning in Roe, not the outcome in Roe. She said it relied too much on the medicalization and the doctor being part of the decision-making process. These cases focused almost exclusively on the woman's right to choose. The doctor was actually a party to the case in Roe versus Wade and was given standing to argue, like, I can't practice medicine, you know. But other states did not find abortion rights. Ohio and Louisiana said nothing in the Constitution says that a woman's right to choose is more important than the fetus's right to life. So we already, prior to Roe versus Wade, see states dividing on what matters more, the woman's right to choose or the fetus's asserted right to life. Some states did expand abortion rights legislatively. So rather than relying on a court decision under state constitutional law, New York, Hawaii, Alaska, Washington State, all enacted sort of abortion on demand laws through the legislative process. This is also another criticism that Ruth Bader Ginsburg had of Roe versus Wade, is that it sort of cut short this legislative campaign where we were seeing activism and shifting public opinion through lobbying, through campaigning, through advocacy and activism. When Roe versus Wade came in and said, yep, everybody has a right to an abortion, that cut that political movement short for a little while. And Ruth Bader Ginsburg's critique was always too far, too fast. If we'd let that social movement percolate more, abortion would have been on a more firm ground when the Supreme Court came in and actually upheld a right to abortion. But that was those movement and legislatively was what she was talking about there. All right, so we get to Roe versus Wade. Roe versus Wade, when it was decided, there was a challenge to a Texas law. There was a separate Georgia law, I believe, that was part of it, but they kind of got dismissed out of the case. So it's focusing on this Texas law. If you ever decide to listen to the oral argument, there's the awkward opening from the Texas lawyer. So the lawyer arguing for the state of Texas attempts to open with a joke.
Oh, really? Abortion?
No, about women.
Oh, really?
It fell a little flat. So it's sort of like whenever a man argues against two beautiful ladies like this, they're going to have the last word. It's not a good joke in any, but anyway, so that was his opening. And it kind of went downhill for him after that. But, so the decision was decided 7-2. And this is important to remember, because most of the abortion cases since then have been closer, either 6-3 or 5-4. But Roe versus Wade was 7-2, and importantly, there were conservative and Republican and Democrat appointed justices in both the 7 and the 2. So this was not party lines, this was not ideological in the same way that we think abortion is today. It took a while for it to get to that sort of ideological sort. At the time, I don't think the justices thought this was a big deal. This was just kind of the next logical step in a progression of cases involving privacy rights. We have Griswold versus Connecticut, which finds a right to birth control for married couples. Eisenstadt versus Baird finds a right to birth control for unmarried couples. And then we get to Roe versus Wade, and it's sort of like, this is just what we've been doing. Have you all been paying attention? It didn't go over so easily. And what the decision actually says is it creates this trimester framework that we may be familiar with. So the trimester framework says that over the course of the pregnancy, the interests shift. At the start of the pregnancy, the decision rests with the woman in consultation with her doctor. The state has very little ability to regulate under Roe versus Wade in that first trimester, the first third of the pregnancy, because the state's interest in the fetus is not solidified in the same way. So the woman has control with consultation with her doctor at that moment. In the second trimester, the state does have an interest in regulating abortion, but in the way to protect the mother, in the way that we would regulate other medical procedures, right? If you're getting surgery done, the state regulates that. There's rules that the doctor has to follow around consent, around sterile conditions, and all of that. And that's where we start to see in the second trimester that the state has an interest now, but that interest is in protecting the mother through the process. It's not until the third trimester where the state's interest in the fetus is highest. And at that point, the state can regulate or prohibit abortion entirely, right? The third trimester, the state's interest in the fetus as a potential person is strongest, to the point where the state can ban abortion entirely, okay? To get to this framework, the court relies on the 14th Amendment and the guarantee in the 14th Amendment of due process. This makes literally no sense, so work with me, okay? You hear due process, it sounds like procedures. What processes, what procedures do you need to follow? That is one aspect of due process that we call that procedural due process. This is what we call instead in Roe versus Wade, substantive due process, an oxymoron if ever there was one. And so what the court is trying to do here is say, the Constitution's guarantee under the 14th Amendment to due process, so let me rewind. Under the 14th Amendment, it says states cannot deprive any person within their jurisdiction of life, liberty, or property without due process of law, okay? That normally means, did you do all the things, did you dot the I's, cross the T's, did you follow the right steps? Under substantive due process, and this is sort of what happened in Griswold and Eisenstadt, those birth control cases, the court says there's more. There's a substantive component to that word liberty. Liberty has meat on its bones. And when the government wants to restrict your liberty, there's some things it can never do. There's you can think of this as there's no process sufficient to invade that right, because it has a substantive component. And that's where substantive due process comes from. This is where the right to privacy comes from, because the word privacy does not appear in the Constitution at all anywhere ever, right? So the court reads privacy rights into the 14th Amendment in Roe versus Wade. Prior to that, they were kind of all over the place. Like in Griswold, we get the famous penumbras where the justice, whose name just blew out of my brain, but the justice who wrote the majority opinion in Griswold is sort of like, there's these emanations and the constitutional guarantees, they have shadows, penumbras that extend beyond. And if you add up the first and the third and the fourth and the fifth and the 14th and the 9th, you put those all together, you get privacy. That makes even less sense. And so the court did that in Griswold, and then they moved away from them being like, oh, that was a little bit rocky. And so when we get to Roe versus Wade, the court says, wherever you think privacy is, it's in there somewhere. And we are pretty confident that it's in the 14th Amendment's guarantee of liberty. This is why the constitutional right to Roe versus Wade has been so controversial is because it's not on a solid, clear, textual foundation. We have to read it in there because the word privacy is not there, the word abortion is not there, and we're really stretching this concept of due process to have this substantive element to it, beyond probably what was intended. So that's our constitutional framework, and that's what leaves it open to change and open to challenge. Okay, and here's what I just said, that a quote. I'm not going to read all of it, but I just want to note, so this right of privacy, whether it be founded in the 14th Amendment's conception of personal liberty and restrictions upon action as we feel it is, or as the district court said in the 9th Amendment, blah, 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 it is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. So the court is saying this is a choice decision on that sense, but
I take the tablecloth down.
I just wanted to highlight this because it talks about how this is important. The detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. They're saying it's apparent what would happen if there's a harm if we deny women this. It's apparent. We don't need to explain it. It's apparent, right? Specific and direct harm, medically diagnosable, even in early pregnancy may be involved. Maternity or additional offspring may force upon the woman a distressful life and future, right? So it's not even limited to health and safety. This is going to be stressful, and having children might deter you from your life goals. The court is taking a broad view of the harm to women if abortion is prohibited, right? This is important language that I think the court eventually starts to forget. Psychological harm may be imminent. Mental and physical health may be taxed by childcare, right? Some of you might know that, right? Because a lot of children, they're cranky, they're loud, they're messy. It's a lot to put on a person, right?
They're cute.
They are cute for like 5 minutes, and then you give them back. Right? But already, this is just like they talk about like even for women who want children, forcing another child on them might be too much. Right? There's a point where the court embraces this pro-woman as a whole person capable of making their choices with their full humanity in context. And the court relies on that. This is a quote from Roe versus Wade in the majority opinion. Okay. Unfortunately, Roe versus Wade is not the law of the land anymore and hasn't been for a very long time. Roe versus Wade is the symbolic case that everybody talks about, right? We have to save Roe, preserve Roe. But Roe really doesn't matter anymore legally, because in 1992, the Supreme Court issued Planned Parenthood versus Casey, a decision out of Pennsylvania. And in Planned Parenthood versus Casey, or the Casey decision, the court rejects the trimester framework entirely. They say that trimester framework is unworkable, it doesn't make any sense, we're going to move away from that. And what they do instead is adopt a flexible standard, right? And that gives the states the ability to regulate even early abortions, right? Though a woman has a right to choose to terminate or continue her pregnancy before viability, it does not follow at all, or does not at all follow that the state is prohibited, did that stop moving while I'm trying to read it? Thank you. From taking steps to ensure that this choice is thoughtful and informed. Even in the earliest stages of pregnancy, the state may enact rules and regulations designed, this is the important part, designed to encourage her to know that there are philosophical and social arguments of great weight that can be brought to bear in favor of continuing the pregnancy to full term. Court says, even in early pregnancy, the state can say, you know what, you really should have the baby. There's lots of reasons you should have it. You have a right to an abortion, but like you really should have the baby. So the Planned Parenthood allows for far greater regulation under the Casey standard. Right? And there's also, as Justice Amy Coney Barrett mentioned in the most recent oral argument, other options for women if they don't want the baby short of abortion. There's adoption, there's the drop-off centers now that Amy Coney Barrett referenced. And so there's these other paths that you can take. So you don't really need an abortion. And the court is saying you can say that. States can require that. Okay. And the way we're going to analyze when the state goes too far is by using something called the undue burden test. The state cannot impose an undue burden on a woman's right to access abortion. Burdens that are due are fine, burdens that are undue are bad. And undue burdens are defined as here at the bottom of the slide. It's undue burden is shorthand for the conclusion that a state regulation has the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. So two things come out of this. One, we have the standard of undue burden, and it shifts the moment of regulation to viability. If the fetus is viable, then the state has an interest that is strongest. Pre-viability, the state can't prohibit abortion, but it can make it hard unless it's a substantial obstacle and thus an undue burden. So they can impose obstacles, they can impose burdens, but they can't impose too many or too much, right? There's no such right to an abortion free of state regulation, the court says, okay? And not all burdens are undue burdens.
Do you want to explain what viability is?
I can explain what viability is. Viability is the point at which a fetus is capable of life outside of the womb. A point that is contested, and a point that is unclear as to whether or not, for example, if the fetus could survive outside the womb with assisted technology, does that count as a viable fetus versus a fetus being able to survive just like without help, right? And the court has not really been clear on that. We're going to find out in a month or two, and we're going to find out that it doesn't matter. But more on that soon. That's a teaser, I think they say. Okay, so yeah, so that's viability. All right. So the state can encourage childbirth over abortion. That is not an undue burden. The state can impose regulations to foster the health of the mother. This can include things like requiring informed consent. Do you know what you're signing up for here at the abortion clinic? Right, we go through the process. That can include, and states have upheld, waiting periods. Here's what an abortion is, here's what happens to the fetus during the abortion, because you didn't know that. Now take 24 hours to think about it and come back. States have upheld that. They've actually upheld 72 hours. Right? In this case, in Planned Parenthood versus Casey, the only burden that Pennsylvania imposed that the court found went too far was spousal notification. Parental notification was fine, waiting periods were fine, everything was fine that was at issue in this particular statute. States have gotten more creative since then. But they said, you cannot require a woman to notify her husband. That is too far because it could be, for example, that there's domestic abuse, so that this would trigger domestic abuse, so that you don't have to tell the husband. But minor child, if you're under the age of 18, you do need to tell mom and dad. That was fine. States have usually included a judicial bypass on that, where it's like you can tell mom and dad or a judge, but you need to get permission from someone. Okay. Children cannot make these decisions on their own. Okay. So post-Casey, we see a massive explosion of states trying to figure out exactly where the line is between an acceptable burden and an undue burden. Because under the common law system, the only way we find that out is sort of through triangulation. The court will say, okay, burden A was too far, so then you try like A minus 5, and is that good enough? And then if A minus 5 is acceptable, then maybe you go back and you try A minus 6, and you put another burden on to C, and you sort of triangulate to find out where the line is. And we've had a lot of things upheld through the undue burden standard. Provider requirements. What are the licensing requirements for your doctor? Do they need to have hospital admitting privileges? Do they need to have what kind of specialized training? We talked earlier in history, midwives used to do this, but now we've made it purely doctors, right? What kind of doctors, what kind of setting do you need to be in? Can you be in an ambulatory care center? Can you be in an abortion clinic? What about medical abortions? Can you get just a pill, and where do you take the pill? All of those regulations have been upheld that make it hard. That's also tying into facility requirements. States will require doctors to provide information to women, seeking an abortion, much of which is often medically inaccurate. Talking about increased rates of suicide, increased risks of breast cancer, and things like that. And so there's medically inaccurate information can be required. in the state's quest to have women choose childbirth over abortion. Certain counseling periods, waiting periods, like I said, 24 hours, 48 hours, 72 hours have been upheld. And if you keep in mind, those waiting periods might not seem like a lot, but if you think about it, there's one abortion clinic in the entire state of Mississippi, one maybe in South Dakota left. So that can be a very long drive there and then another drive back 3 days later. For some women, that means that means 2 days, 3 days of lost income, hotel fees. It just adds to the cost, especially when, if you see here on the bottom, states prevent even private insurance from covering abortion as a medical procedure. So you have to pay out of pocket for the abortion. Federal law prohibits Medicaid from being spent on abortion. So the health insurance program for low-income people cannot be used for abortion under the Hyde Amendment. Is that changed?
There's some
exceptions. Yeah.
We'll talk about it in a minute.
States have also required women to listen to the fetal heartbeat and/or view an ultrasound of the fetus prior to the abortion. These include very early term abortions when a transabdominal ultrasound would be insufficient to pick up the fetus for visualization, which means you've got to get the ultrasound wand closer. And it will let you think about human anatomy to think about where you're going to put the ultrasound wand to get closer when an abdomen doesn't do it for you. So you got to send that up there.
And think about re-traumatizing individuals who their pregnancy occurred because of sexual assault and the re-traumatization of these individuals. So
yeah,
it's a lot.
So yeah, and then some of these laws actually require the woman to look. It's not even that they require the ultrasound to be performed. The woman has to look at it and like sign a thing that she looked at it and heard the heartbeat. So yeah, and those have all been upheld. And now it's your turn. And I'll let you click your slides.
So I'm going to tell you a little bit more in specifics, some of the state laws that exist. And I encourage you to check out one of my favorite websites out there. It's the Guttmacher Institute. And they are a fantastic resource of all kinds of reproductive health policies that are out there. It's mostly, they're looking, tracking state. And I'll tell you some interesting statistics here in a little bit. But this is just kind of a snapshot of what's going on. So in terms of physician and hospital requirements, so like Dr. Cameron was talking about, there are 36 states that require abortions to be performed by licensed physicians. So there are still some states that allow non-licensed, so maybe a midwife or maybe a physician assistant or nurse practitioner or something along those lines. 19 states require abortion be performed in a hospital. So while this could be a quick kind of outpatient procedure, you have to go through the entire hospital process, which, as you know, anyone who's had to have a hospital stay, how expensive that is, and they charge you $1 million for a Tylenol. So it gets very expensive, and insurance doesn't necessarily cover that. And then 17 states require the involvement of a second physician, so it can't even be done by one. A second one has to be present and involved in kind of a second opinion in order to have that happen. Again, think of what the costs look like and how difficult that can sometimes be. Some of the other hospital requirements are things like non-hospital facilities might have to have very, very wide hallways. So, you know, they have that in hospitals because you have to get gurneys down, but gurneys are not necessarily needed in certain types of facilities that might perform abortions.
Some of those are shut down in a woman's house.
Some, but
yeah,
not
some
all.
not all.
Yeah, some not all. Or even like the electrical that has to be present in these facilities. And so it's a way to try to really narrow some of the provisions from Roe and also Casey. In terms of gestational limits, 43 states prohibit abortions after a specified point in pregnancy. So specifying what that is, and as you can see, there's about 43 different types. There are some allowable exceptions, such as protecting the life and health of a patient, but not all. Partial birth abortions, 21 states prohibit partial birth abortion, and we can talk a little bit about what that means later if you have questions. When it comes to public funding, 16 states are allowed to use or have made it available to use funds to pay for all or most medically necessary abortions for Medicaid enrollees.
Are they using the state contribution funds for that? Okay, yeah.
Yeah.
I thought the federal funds still can't go.
There are some. When federal funds are available, not in all, but when federal funds are available, 33 states and DC prohibit the use of the state funds to use the federal funds instead. And then South Dakota limits funding to cases of life endangerment only, which goes against some of the federal laws. When it comes to coverage by private insurance, there are 12 states that restrict coverage of abortion in private insurance plans. So you can get a private insurance and the state says, I'm sorry, it cannot cover any sort of abortion coverage. However, many of the states allow you to purchase an additional coverage. So you have to pay more money. So if you think I might need to have this procedure, then I paid more money to be able to have that covered. And we all know that insurance coverage is just astronomical. So this is not an option for the vast majority of individuals. This is an interesting one as well. We probably get into long conversations about this, but there's also a lot of conversation about refusal to perform abortions. So 45 states allow individual providers, so any doctor can say they will not perform an abortion. And I'll come back to this in just a second. And 42 states allow a particular institution not to refuse to do these. A lot of these 42 that allow institutions to refuse, there's a lot of times exceptions for religion, things of that nature. This becomes problematic for people who, like for instance, in Mississippi, where there's just really no way to get an abortion other than a few places. It becomes very, very difficult. In addition to this, that oftentimes gets conflated into this conversation, there are even more states that allow pharmacies to refuse morning after pills, and the pharmacy can refuse it or the individual pharmacist. So if I'm a pharmacist, as a pharmacist, I can say, I'm not going to dispense that, but Dr. Kammerer is happy to do it. So there are different laws about that. There was a study that was done about 5 years ago where they sent people out to see who could get access to the morning after pill. And on average, women had to go to 6 different pharmacies to be able to find a place to actually get it. So if you're thinking someone who is in a bad situation, who it might be, an emergency, maybe they don't have a vehicle, maybe they don't have means to be able to try to track down a morning after pill can be quite difficult. Dr. Kammerer also mentioned state mandated counseling, and this counseling, I think in many ways counseling sounds like a fine thing to have people do, where women will have to have certain information provided to them before they're allowed to choose an abortion. But a lot of this quote unquote counseling is not medically substantiated information. So there is not medically substantiated information that there is a link between abortion and increased cancer. That's not actually a thing, but 5 states mandate that this be told to women trying to procure an abortion. There are 13 states that require the provider to talk about fetal pain and that a fetus can feel pain during the abortion process. Again, not substantiated medically. And then finally, that there are mental health consequences such as depression, anxiety, etc. 8 states require this. The interesting thing about these, and there's not really been a huge set of decisions made just yet or some clear standards yet, is the question of whether or not this goes against the free speech rights of healthcare providers. So for instance, I think we would probably think that if there was some sort of curriculum that came in and said, Dr. Kammerer, Dr. Kirkpatrick, Dr. Johnson, you have to say all this untrue information in all of your classes. We would say, wait a minute, that's a violation of our First Amendment. And also it's a violation of doctor-patient care, right? That you would have to tell your patients things that don't have a strong grounding in medical science. So these are interesting laws. They've tried to challenge them. Not a lot's happened with it.
Most of them have been upheld. The free speech, the doctors have lost, I think, every free speech case that they've brought.
Yeah.
There've been a lot of doctors who are like, you can't make me say this. And then basically the predicate is you're a regulated profession, so it's not really your speech. Like we get to say things like this. Like we require you to go over informed consent for every medical procedure. So really you have no First Amendment leg to stand on.
There we go. Sorry, I forgot to change it on my phone, but not here. Dr. Kammerer also talked about the waiting period. 25 states require a person to wait a specified period of time. Most of those 25 states are 24 hours, but some are up to 72 hours. And some require so much distance in between the two of them that there's absolutely no way it can be done unless it's happened in 2 visits. So like Dr. Kammerer said, someone would have to travel. If you were having to travel across an entire state, that might be very difficult. Hotel costs, 2 days of lost income, etc. So it becomes quite a burden. Apparently we decided it's not undue.
It's not an undue burden, it's a perfectly reasonable burden.
And then parental involvement. 37 states require some type of parental involvement. 27 states require one or both parents to consent in order for a minor to receive an abortion. And 10 require that one or more parents be notified. So not consent, but at least be notified. So lots of interesting things happening there. And you might think, well, then, this is kind of the realm of actually what's happening. But because abortion has become so incredibly politicized, both sides have become active, and they've done a really good job of naming themselves, right? So if you think about pro-life and pro-choice, I mean, both sides have an excellent point, right? Pro-life, who doesn't love life? We all do, right? Pro-choice, who doesn't love to be able to have choices? We all do. And so they've done such a good job, and they've been very, very active. And I want to give you kind of an example of what this looks like. As of March 31st, 2022, so just a few days ago, I guess maybe a little more than a few days ago, there have been approximately, and this is since January, 742 provisions on abortions introduced at the state level. So that's not 742 policies. One policy might have 8 or 10, 15 provisions in it, but 742 different provisions. And like I said, the Guttmacher Institute goes through all of this. They track exactly what's going on. A few examples of these, and I want to point out, not all of them are something that would be super prohibitive, right? So for instance, 85 of the 742 are about increasing opportunities for telehealth, right? And that's great, right? For people to be able to access doctors without having to travel long distances. But a lot of them create all kinds of different provisions. One, banning abortion due to genetic anomalies. So if they know that the fetus is going to have some sort of problems. 5 states have introduced that. 5 states have introduced a ban on abortion for race selection. I would think that that's probably something we may not have too much argument. 7 introduced over a ban for sex selection. There have been multiple bans at 6 weeks, which we'll talk about here in a little bit. 6 different states have introduced provisions that grant a fetus personhood, so they become quote unquote citizens of that particular state, and therefore they are entitled to more rights or the same rights as any individual and citizen.
Can I add something on that?
Please.
The Supreme Court explicitly rejected fetal personhood in Roe versus Wade. That was part of the arguments raised by Texas. And the Supreme Court was like, yeah, no, we're not doing that. That may or may not stay the law.
And there are states that have fetal personhood.
Right.
Anyway, right? These are just the ones introduced since January.
Yeah. So there is an argument. That is, we're gonna when we get to the end, we're gonna talk a bit about fetal personhood again. But as of right now, the Supreme Court has rejected that. Whether or not that rejection continues is an open question.
Mm-hmm. And I think it's also important to remember that state laws stand until they are challenged, and so you can adopt laws whenever you want to that are completely unconstitutional until someone does something about it.
Blasphemy is still against the law on the books in Massachusetts. No, because there's no point in repealing it, right? It's unenforceable, but it's still on the books.
I use that as an example when I teach a lot because I tend to blaspheme. Not while I'm teaching, just in general. It's like a life motion. It's like a life philosophy.
This one down here, I'm kind of sitting in front of it, so I'll read to you. I thought was really interesting. One state has said that a provider may prohibit or may omit any sort of pertinent medical information that could lead to abortion. So, like if, for instance, if a person knew that their potential child might have severe disabilities or severe problems, they can not tell the parents about that if that would lead to them wanting to have an abortion. One state has
Pregnancy is
introduced
more
that.
risky than abortion in early
Absolutely.
abortion. So that's another thing that could potentially be omitted here. The risk to the woman is greater from childbirth than a first trimester abortion.
And I counted all of these up, and there are 47 different types of provisions that have been introduced since January. So lots and lots. I just gave you a small sampling of what some of these 742 provisions look like. Not all have been passed, but this shows the level of activity of individuals or groups that are really trying to push for more restriction on abortion. And I think this leads to a conversation about venue shopping, right? So where have people who want to restrict access to abortion been most successful?
South Dakota.
Yes, but state legislatures is where they have been most successful. And so that's where these groups have been focusing most of their attention. All right, despite all of that legislation that's going on at the state level, it's really important to note that the American public, and I want to specify this in the aggregate, which means considering the entire US population, it's not a black and white issue for individuals, right? It's not, so many people are for, so many people are against, but it's a very nuanced conversation. And I think that's probably the case with a lot of morality politics. So opinions vary by a variety of different contexts. So the context of the case, so did the pregnancy result from rape or incest, or is there a severe threat to the health and safety of the person carrying the child? Also, it obviously is divided by religion, party identification and ideology, gender, race and ethnicity, age, and education. So I want to show you a little bit about what public opinion looks like in the United States currently. So hopefully you can see this. This is looking at public opinion when it comes to over time, I guess, on whether or not it should be legal in all or most cases or illegal in all or most cases. So legal in all or most cases is this top line. So you can see that since 1995 clear up till 2019 is where it goes. Yeah. More people support that abortion should be legal in all or most cases. So we're roughly at about, go ahead, I'm sorry.
I don't know if people can see that, especially on Zoom. That's above the 50% line for almost that entire period with a slight dip around 2010.
So yeah, we're definitely in the 60, mid to upper 60s here. All right, if we divide this up by when it should be legal. So about over 25% say it should be legal in all cases. Another 40%, 40%-ish say legal in most cases. So this is, it should be legal in almost all cases except for, as a method of birth control is kind of what they're talking about. Illegal in most cases. So people say it should be illegal, but there should be exceptions, most notably for the health and safety of the mother. And then if you look down here, roughly around 10% say that abortion should be illegal in all cases. This is not a black and white issue for people. There's lots of variation. You can also see the variation when it comes to religion. We see the most strongly against, I suppose what we could say, is among white evangelical Protestants. And then to a lesser extent, white mainline Protestants, black Protestants about the same. Catholic is even lower than white evangelical Protestant, which I thought, based on a lot of the conversation, you might think would look different. And then those who are unaffiliated are much more likely to say that abortion should be legal in all or most cases. If we look at the differentiation, this is probably no surprise to anybody. If we look at ideology and party affiliation, we see conservative Republicans, obviously the most likely to say that it should be illegal in all or most cases. Moderate and liberals a little bit more split, but lean more towards legal. Conservative or moderate Democrats, more legal, and liberal Democrats, as you can see, much more supportive of legal in all or most cases. We also see difference between men and women, but not as starkly as you might think. So there are similar distributions. And then down here, gosh, you can't see this at all, similar distributions when it comes to white, Black, Hispanic, and Asian. The last one, I think this is the last one here. We're looking at age. We can see young people more likely to be supportive of legal in all cases. But look, across all age groups, still more people say legal in all cases. And then education, those who have college or graduate education, most likely to say legal. All right, back to Dr. Cameron.
All right, so right now there are two sort of major cases pending in the Supreme Court, challenging the rights enshrined in Roe versus Wade and Planned Parenthood versus Casey. The first one that I want to talk about is the Texas case. So the Texas case bans abortion after 6 weeks. 6 weeks is calculated from 6 weeks from the woman's last menstrual cycle, last period, which means you might not know you're pregnant until basically your 6 weeks are up.
Yeah. And I want to make a comment on that really fast. So all of us ladies know every time you go to get any sort of doctor checkup, they're going to ask you, what was your last menstrual cycle? And I don't know how many people do a great job of tracking any of that. I don't know. Mine's always like, I don't know.
There's an
pick
app
a
for
random
that.
date here. There is an app for that, but really? That's
like
not a
10
cool
apps.
stuff. I don't want to track. But this means that at 6 weeks, very few women know they're pregnant yet, right? Especially if it's not something that you've been planning for or are purposely attempting. So that's very easy to not have any idea that you're pregnant at 6 weeks.
Yeah, so this is basically now creating an effective ban on abortion in Texas because of the fact that most women who would want one don't know they're pregnant before the 6 weeks have passed. And this law is currently in effect while the litigation is pending because the Supreme Court has refused to put a stay. We call it a stay. It's basically pushing pause. And the Supreme Court has refused to do that. So the law is currently in effect. The more, I don't know if it's more concerning, equally concerning part of the law is the second thing that it does, and this is actually the most ingenious part of the law, is what it does is that's I am trying to be somewhat neutral. I pretend sometimes to not have opinions. But yeah, so what this law in Texas does is it creates a private right of action. And what that means any person anywhere can sue any person who helped a woman get an abortion, and if they can prove that that person helped a woman get an abortion, they get $10,000 from the person, okay? And you need no connection to the woman. You could just be like a stranger on the street. Or I saw, what is her name in the Crucible? I saw Goody Proctor going to the abortion clinic, right? And you can sue, okay? And what this does, of course, is create great liability. Because even if the person that is sued wins, they have to pay for that defense, that legal defense. There's no what we call fee shifting for the defendant. The defendant pays their costs, win or lose. So yeah. So and what this And keep in mind, I have strong feelings about this. Keep in mind, this is also creating a civil right of action. So remember, the burden of proof in a civil case is preponderance of the evidence. Is it more likely than not that this is true? 50% plus 1. This is not beyond a reasonable doubt like in a criminal case, nor is it what we sometimes see in family law, what we call clear and convincing evidence, which I usually say is around 75, 80% sure, right? This is 50% plus 1. Is it more likely than not? And you can sue everybody from the Uber driver to the abortion doctor, okay? Everyone at $10,000 a pop. Okay. Other states are now following this.
Side hustle.
I know, I mean, that would pay off my student loans. I would feel bad about it, but it would pay off my student loans. Like one abortion really would pay off my student loans. Right? So anyway, the point is, this is creating, but that's the incentive. They want everybody to do this. They want people to think about, I could use that money. Right? And so that's what Texas did, and this is ingenious. And the reason it's ingenious, and this is the most insidious part of it, is because it's a private right of action. You cannot sue the state to have the law declared unconstitutional because the state's not doing anything. They're out of it. Right? Because when you sue someone to prevent the law from being taken into effect, you usually sue the state or the attorney general or whoever is the person who's in charge of enforcing the law. But the only person in charge of enforcing the law is the vast majority of the public of Texas. And you can't sue them all because you don't know all their names, and you can't put them all in a lawsuit. And that's the issue why this law has been able to go into effect, because there's no one you can sue to stop it. And that's why this law was crafted the way it was. And other states are now adopting this language and this idea as it percolates out. I want to say that's in Idaho's law. So we've got this now here too. Idaho did at least limit it. You can't sue everybody, and not everybody can sue. It's limited to basically the men who own the woman having the abortion. Because apparently we're going back to coverture. But it's basically parents, siblings, grandparents, and children, I think. I'd have to look up the language again, but it's basically people who are related to the woman can override the woman's decision to have an abortion. So if you're getting an abortion and your parents disapprove, they can sue your abortion doctor. That's okay. The other case, and this is the one that we're most likely to get a decision in first, is Mississippi or Dobbs versus Jackson Women's Health Organization, which is, I believe, the last remaining abortion provider in the great state of Mississippi.
There's a really great documentary out there called The Last Abortion Clinic, which is completely about this particular abortion clinic. So yeah, I think it's free on PBS, so check it out.
And so the law in Mississippi, initially, the law says abortion is banned at 15 weeks. And this is pre-viability. Viability is usually 22 weeks. So this is trying to move that line. Remember, the Casey line says viability is the marker. This lawsuit, or this law in Mississippi, was nudging that a little bit and saying, we're not going all in. We're only going to go to 15 weeks. You're good with 15 weeks, right? 15 weeks is reasonable. If 22 weeks is fine, why 15? Yeah, okay. But subsequent to this case getting to the Supreme Court, there was a personnel change. To this litigation starting, there was a personnel change because Ruth Bader Ginsburg died and was replaced by Amy Coney Barrett. And so the conservatives now became solid 6-3, where before, at least on abortion, they had a somewhat tenuous 5-4. Because Roberts occasionally, if the law was a little egregious, would vote with the liberals on an abortion case. He did that in a case out of Louisiana, June Medical. I want to say it was Louisiana. He's like, this is literally identical to precedent. Can you give me something that's not literally identical to precedent? Maybe I can do something different. But this now, the way that the case is framed in the Supreme Court is actually asking a broader question about whether or not states can ban all pre-viability abortions. Like, they're going for it. They have asked the big question and they want the big answer. And we'll find out in June. I say June because the Supreme Court usually waits till June to handle the controversial ones, and then they skip town for the summer. So probably in June we will hear the ultimate answer to this question. But that is why this is phrased the way it is. So those two cases are what's pending. What happens after that?
So there are a variety of different laws that are in place. Some of the ones that are pending, decisions that would basically waiting on the outcomes of these Supreme Court cases, what might happen. There are other states that have passed what we call trigger laws, which I think is absolutely fascinating because in many ways they are just symbolic legislation. And what they say is, if Roe is ever overturned within the state of Texas, for instance, abortion would become immediately illegal. So then it would go back to the states. And so there are 26 states that have trigger laws of some sort in place that, depending upon what the Supreme Court does or might ever do in the future, where abortion will become illegal. And so that's a substantial amount of states, right? More than half the states have something like this on the books, which some of these have been around for 10, 15 yees, especially I think over in most of the southern states. They've been there for quite some time.
And note the distribution here, because we want to keep in mind, if you're a poor person needing an abortion in Mississippi or Alabama, like you've got a long ways to go till you see one of those states where you might have some hope of getting an abortion. The added cost of this being these states being so geographically concentrated is going to fall most heavily on the most disadvantaged. And that's not really something you can like save up for. Right? It's kind of a time-sensitive issue.
So when we think about a lot of the implications of, what if, these cases pan out in a way that put more restrictions on abortion, what happens? And there's so many implications for women. A lot of that has to do with access to safe medical procedures. A lot of abortions occur because, like Dr. Kammerer said before, pregnancy is sometimes more dangerous than an abortion, right? So if there's some sort of risk to the mother, the health of the mother, and that doesn't just necessarily have to mean physical health, but it can also mean mental health. There are a lot of conversations where access to safe medical procedures is necessary. This kind of relates back to the idea of trying to legislate a morality issue. And there's some really cool research out there that talks about morality politics in general. So there's an article by Ken Meyer, and it's called Sex, Drugs, and Rock and Roll. So it's got a great title to it. And what he talks about is that the demand for what he calls these quote unquote, I don't want to pass judgment of these sin activities, we have a really realistic idea of what the demand for it is, right? A lot of people say, well, if abortion is illegal, everyone's just going to have abortion left and right. And that's just not true, right? Like most abortions happen for, really terrible situations. And so we oftentimes think there's this big demand, and it's just not necessarily the case. And so what happens when you make this not available? Well, we end up having things like people going to other countries or trying to drive to one of those states to be able to have access to reproductive health care, or maybe even taking things into their own hands, which we know is obviously not safe. And as we talked about before, the sharpest impact happens on poor minority women who sometimes may not know they're pregnant until very late. They haven't had any prenatal care whatsoever. The pregnancies are often very, very high risk. And so it creates an even bigger burden on poor minority women. The other thing that this potentially leads to, right, and we're kind of spinning this out, we have to talk about the slippery slope. If we make this decision here, what does it then lead to later on? And this is the idea of criminalizing motherhood. And what we mean by that is if we start to say that, an abortion, at any point in time, like the Mississippi law is trying to get at, is akin to murder. What happens if a mother is driving a car, a pregnant woman is driving a car, doesn't wear a seatbelt, gets in a wreck, and the fetus dies? Is she then criminally liable for the death of the fetus? Or if someone refuses to take prenatal vitamins or doesn't know that they're pregnant or doesn't get proper medical care ahead of time, what kind of liability is that for even entering into the idea of becoming a mother? So women often or always bear the consequences. I have never seen any sort of law anywhere that says, and here the man who is also responsible for this fetus also has these consequences. It's
Like
nowhere.
child support is not starting at conception.
Exactly. And so women bear all of it, and that's a lot, right? All right, implications also then for parenthood. These questions of ending life before it even begins. It has all kinds of implications for contraception, like I talked about the morning after pill, which really honestly is just a large cocktail of regular hormones and birth control.
Can I add something on that?
Please.
I just want to, I don't know if you guys might remember the Hobby Lobby decision
Yes.
from back in the day. Hobby Lobby decision upheld Hobby Lobby's religious freedom claim to deny 4 forms of birth control from their health plan for religious reasons, because Hobby Lobby considered those 4 forms of birth control to actually be abortion drugs. And so they were able to assert a religious objection and have those 4 forms of birth control. I think it was 4 forms of birth control. I keep saying that, so I'm assuming it's 4. I don't just make numbers up out of my head usually. Forms of birth control that were required under insurance plans under the Affordable Care Act to be available to all female employees. They were able to get a religious exemption because they equated contraception with abortion. So it's not far-fetched to see other forms of contraception equated with abortion. And because the line of cases all rest on the same interpretation of the 14th Amendment, that it includes privacy, if abortion goes, contraception could also go.
And it also has absolute implications for assisted reproductive technologies. So individuals who are not able to have children without the medical intervention can have huge implications. So for instance, if a couple decides, or an individual decides to utilize implantation of embryos, so external fertilization, oftentimes they will fertilize probably 10, 15 embryos and then cryogenically freeze those. And you can cryogenically freeze gametes, but they tend not to do as well. So you want to freeze the embryos. So this is post-fertilization. And if they end up not utilizing those embryos, then they're just held in like a stasis, I guess, for all eternity. So if we start to have these conversations about not being able to have abortions, even pre-viability, what does this then mean for abortion or for assisted reproductive technologies? So for instance, if one of these places that holds these embryos, the power goes out, is someone then responsible for mass murder of all of these embryos? Is it ethical to hold embryos in stasis for all eternity? And what happens even years and decades beyond when their parents are even alive? So what does this mean? And this is, a lot of states have refused to even touch these types of laws because the reproductive or assisted reproductive technologies industry is like a $6 or $7 billion industry. And so they're very, very concerned, like, okay, if we introduce these laws, what's going to happen? And this is really good for our state economy. In fact, in the state of Georgia, there were some laws that were being considered, and one of the most conservative state representatives came out and said, wait a minute, we got to shut this down because people travel from across the United States and from across the world to come in and get assisted reproductive technology treatments in Georgia, and that would significantly hurt their economy. So I don't know what will end up happening and who might mobilize if some of these Supreme Court decisions pan out in certain ways.
Okay. Do you want me to do the plug so it doesn't feel awkward for you?
Yeah, go for it.
Or do you want to do it?
No, go for it. Go for it.
So if you want to learn more, before we turn to the Q&A, I just want to flag my dear colleague is teaching an entire class on this for a whole semester. Next semester, reproductive health policy. I'm not going to read the whole thing.
It's very long, sorry.
It's very long course descriptions, but you can see from the length of the course description, the breadth that this class is going to cover. It's going to be awesome. Lots of seats still open if you need a fall class. Undergrad and grad level joined together.
One thing I'll say about the classes, I think sometimes when people hear reproductive health politics, everyone's like, oh, it's just going to be about abortion and contraception all semester. Absolutely not. We're going to talk about all kinds of things, even to cloning and, you know, can you patent your own genetic material? You know, how do people decide to become parents? How do they decide not to become parents? It's going to be, I think it's going to be an awesome class. I love to study the things that get people's blood pressure up. So, right? So come, bring your blood pressure medicine. We'll have a good time.
And I think that's it. So I'm going to scroll back to the first slide. It says the least text on it for
Yes.
our Q&A.
Yeah.
So